Hi everyone, I welcome you all at Apti Plus IAS platform. In these particular videos, we are going to analyze Hindu and Indian Express editorial articles. In these particular videos, we'll not just only discuss issue that is given in editorial, but rather we are going to discuss these particular aspects, these particular articles from background. We'll discuss the main concept as well as way forward. And also you'll find that the notes have also been has been arranged in the format of context, body and way forward. So now let's get started with the video. In this particular video, we are going to discuss all the aspects with respect to recent Supreme Court judgment on sub-categorization of SC reservation. This particular judgment is formally known as State of Punjab versus Davinder Singh case. Let's get started. First of all, there are some basic aspects of polity that you should understand. You see this particular thing, guys, that there is Article 341 in the Constitution of India. This article provides that President has the power to declare certain communities as scheduled caste. To declare certain communities as scheduled caste. Now, the communities which are declared as scheduled caste, they are entitled to affirmative action reservation under Article 15 and 16 of the Indian Constitution. First question comes that why they are given reservation. So you see this particular thing, reservation is given keeping in mind two principles, that is principle of anti-dehumanization and principle of reparation. What does it means? Now, because of the Varna Vyavastha, the Shudras, many of them, they were declared as and they were treated as untouchables. And because of that, a lot of disabilities were imposed on them. Many number of a time, inhumane treatment happened. They were not given equal opportunities in education, employment. So a kind of a dehumanization of the scheduled caste people, Dalits, have happened. To prevent that, some safeguards are to be given, and that is affirmative action. So principle of anti-dehumanization provides that you take some steps so that they are not dehumanized. You give them some additional safeguards, and we are giving it. Then second is principle of reparation. Now, what does principle of reparation means? Reparation is to make up for the harm that has happened. So hundreds and hundreds of years historical injustice has happened with the Dalit people, and in order to make up for those historical injustices, they are now being given the reservation. So always understand this particular thing, that SC reservation is not for poverty reduction. It is even in regard to principle of anti-dehumanization and principle of reparation. Now, using the Article 341, President of India way back in 1950 issued the Constitution Order of 1950, which declared that which communities will be the scheduled caste, and post that many number of times this particular list or this Constitution Order of 1950 has been revised also. Now, this scheduled caste reservation was going on. Now, guys, when we talk about the quantum of reservation presently, you see this particular thing. On social criteria, we give reservation to scheduled caste. They are given 15% reservation. Scheduled tribe are given 7.5% reservation. After the Mandal Commission recommendation, OBCs, other backward classes, they are given 27% reservation. Then there was 103rd Constitutional Amendment Act that provided EWS reservation also. And EWS, they get 10% reservation. So first of all, today we are giving the reservation to the tune of 59.5%. This is the total reservation that we are giving. Now, when the scheduled caste reservation is concerned, so there was one development that happened in 1975. 1975, Punjab, they brought sub-categorization within the SC reservation. So the scheduled caste reservation that they were giving, in that what they did, they provided that Valmikis and Mazhabi Sikhs, out of the total reservation that Punjab is giving, 50% will be going to Valmikis and Mazhabi Sikhs, and remaining rest will go to the other SC community. For example, just to simplify the things, suppose there are the 100 seats for the SC category in a particular job. Out of this 100, 50 will be reserved for Balmikis and Mazhabi Sikhs, and remaining 50 seats will go to the other SC communities. So this sub-categorization they did. Now guys, as they did this particular sub-categorization, this particular thing continued for approximately 30 years. Now, what happened? Meanwhile, Andhra Pradesh also took this particular kind of a step. Andhra Pradesh, they passed Andhra Pradesh Scheduled Caste Rationalization of Reservation Act 2000, and they also subcategorize the reservation. Okay, they also subcategorize the reservation. Now, guys, these all things were going on. And what happened then in 2004? There was one more judgment that came, and this was E.V. Chinaiya case of 2004. In this E.V. Chinaiya case of 2004, Supreme Court declared this particular thing, that subcategorization within the SC community is constitutionally invalid. They provided that there is a challenge on two fronts. First of all, subcategorization is invalid because of Article 14. Now, what you are doing? Suppose this is the entire scheduled caste community. Now, you are giving a particular number of seats to this section, particular number of seats to this section, and likewise. So, you are treating them unequal. It is violative of Article 14, that is the right to equality. So, therefore, it is invalid. Secondly, they said this particular thing, that under the Article 341, it is President who is empowered to declare the SC list, to modify SC list. It is the President. So, how state government is doing this particular thing? Now, this E.V. Chinaiya case was given in the context of Andhra Pradesh. But as this particular principle has been upheld, even the Punjab, who has earlier subcategorized in 1975, that particular thing would also become invalid. So, what happened? Consequently, Punjab and Haryana High Court, in one of a judgment, that is the Kishan Pal case, they declared that even 1975 notification of Punjab government is also invalid, and therefore the subcategorization for Punjab was also removed. Now, the question that emerged here is that what is the status of subcategorization? Can the SC reservation be subcategorized within the SC community? Can we subcategorize the reservation for different people or not? Now, you see, Punjab, what they said? They said that actually E.V. Chinaiya judgment is not correct. Why? Now, just we will be discussing here about one more case, that is the Indra Sahani case of 1992. Now, Indra Sahani judgment was actually given in the context of OBC. In this Indra Sahani judgment, the court recognized the possibility of subcategorization within the OBC. Now, you see, within the OBC, there is a creamy layer, non-creamy layer, and the principle of subcategorization was also accepted in Indra Sahani case. Now, Punjab government said that as it has been recognized for the OBC, subcategorization by legal logic will also be, should be applicable to the SC and ST community also. So, it was provided that it should also be applicable to the SC and ST community. So, therefore, subcategorization should be given. Moreover, then there are the other arguments that have also come, and these arguments were made in the present Supreme Court case also, that is the state of Punjab versus Davinder Singh. Now, what are the other arguments? So, there is argument that comes from the Article 16 subclause 4. Now, what is this Article 16 subclause 4? So, I'll show you this. Now, here we have the Article 16 subclause 4. Now, okay, I hope it is visible to you. It reads, nothing in this article shall prevent the state from making any provision for the reservation of appointment or post in favor of any backward class of citizen, which in the opinion of state is not adequately represented in service. Okay, so it says that there is not the word equality that is mentioned. Here the word that is mentioned is the caste which is not adequately represented. So they say that suppose this is the entire SC community, and within SC community, let's say there are 20 communities that are there. There are the 20 caste within the SC community that are there. Maybe two or three are the one who are getting the maximum benefit, or maybe 2 or 3 could be the one which have not got any benefit. So they are not adequately represented. So therefore, for them, we can come out with the special provision. Special provision is something like that, that out of total SC reservation, 10%, 5% has to go specifically for these particular communities. So state says that Article 16 subclause 4 gives us the power. It gives us the power to make special provisions, okay, for the reservation in favor of any backward class which is not adequately represented. Punjab says, and Andhra Pradesh Tamil Nadu, many states says that there are certain castes which are not properly represented, and for them we are bringing this subcategorization. Okay, so this is one that has happened. Then guys, after that there is also one more argument that is made, and that is with the help of Article 342A. Now what is this Article 342A? Let's understand this also. So you see that Article 342A, we have this subclause 3. We have this subclause 3. What it says? It says that state or union territory may by law prepare or maintain for its own purpose a list of socially and educationally backward classes which may be different from the central list. Now, though this is given in the context of socially and educationally backward class, what has happened? The states, they have said that even for SCs, internally they can have a separate list, a differentiated list, and by that logic, even subcategorization, a state for its own purpose can also maintain. So these are some logics, these are some justifications that have been given in this particular respect. Then after that, guys, what happens? After that, guys, what happens? When we, in fact, we read the Article 341. Now, Article 341, I'll remind you, this is the same article which empowers the president to declare the communities as scheduled caste. So it is said that in the same article, Article 341, there is a subclause 2. It restricts the state, but it restricts state in some limited circumstances. For example, state cannot add any community as a scheduled caste community. State cannot remove any community from the SC list. Now the states say that we are not adding or removing. Simply within that particular list, we are subcategorizing. We are keeping aside certain seats for some specific community within the SC. Neither we are adding nor we are removing. Just internal reorganization we are doing. So therefore, there is not a problem. So now, guys, what actually has happened? So now the Supreme Court in the state of Punjab versus Davinder Singh case has ruled this particular thing, that in E.V. Chinaiya case, the judgment that was given, it was wrong. It has been said that SC community, now listen very carefully, it has been said that SC community is not a homogeneous group. There are certain sections within the SC which are far more deprived, which are far more marginalized, and for them subcategorization should be done. And it has been said that the states have the power to subcategorize the SC reservation, and that they have to do on the basis of a quantifiable data. They cannot do it on their own whims and fancies for political purpose. They cannot do. They have to show a quantifiable data that this particular community is not properly represented in the job or in the post, and therefore we are reserving it. So one, this has been provided. Second, it has been provided that if the state is subcategorizing the seats for the SC, it is subject to judicial review. Okay, court can go in the intention of the state. Okay, so judicial review will be there. And then the other things that have happened is the Supreme Court has also provided this particular thing, that now time has come that we need to come out with the creamy layer concept, evolve the mechanism to declare a creamy layer even in scheduled caste and scheduled tribe communities. Now, what is this creamy layer? So basically the idea of creamy layer already applies in OBC. So within OBCs, the OBCs are divided in two categories, that is the creamy and non-creamy. Non-creamy OBCs, they get the benefit of reservation. Creamy layer OBCs, they don't get any benefit of reservation. It is assumed that the creamy layer OBCs have got advanced. So there are the criteria. For example, if your parent is holding some constitutional post, then the children will be creamy layer. If they are doing some profession, then the children will be creamy layer. So creamy layer concept as of now was not applicable in SC and ST community. It was applicable only for OBC. Now Supreme Court said that even for SC ST community, creamy layer concept should be applied. State should come out with some kind of a policy. Now a question will come that why they are bringing this particular creamy layer concept here. It is because of the fact that actually in 2018, there is one more judgment that has already come. That is Jarnail Singh versus Lakshmi Narayan case. In this particular case, Supreme Court ruled that in the matters of promotion, now listen very carefully, it is not in the matter of appointment, but it is in the matter of promotion. Suppose there is a person from SC community in the matters of promotion, the people can be excluded on the basis of the creamy layer concept. So within the SC community, creamy layer concept will be applicable in the matters of promotion only. Now they say that it is to be expanded to the other areas also. Now, moving on, there is one more issue that comes here, and the issue is this, that whether this thing is going to be feasible or not. So let's analyze this particular dimension. Now guys, you see that there can be certain positive and some negative aspects that can develop. First of all, what are the positive things that will come out of this? Positive thing that come out of this. Now, as the Supreme Court has recognized the idea of sub-categorization, now there is an opportunity to give representation to more marginalized section within the SC community. So this is a good step that we have, number one. At the same time, there can be the political usage of this particular thing that can be done just to get the vote bank, or just to get the political advantage. The subcategorization can be done by the certain states. This is a challenge that comes here. Then one more challenge that comes here is that there is a condition that a quantifiable data is to be maintained, but this is not clear that how or what exact parameters state are going to use in this particular capacity. One good thing that has come here is that now Supreme Court is slowly recognizing the idea of inclusion of creamy layer concept within the SC community. Now these demands have been for a very long period of time, that there are certain communities which for multiple generations had got the benefit of reservation. Now it is the point to exclude them, and here the creamy layer concept is going to be helpful. Okay, but at the same time guys, is creamy layer concept going to be a very good one? Now, if we just go back, you remember that we discussed that reservation is given to ensure that dehumanization of people don't happen. Now you see this particular thing. This is true that over the generations, many people are the ones who had got the benefit of reservation, and for 2-3 generations they are in the government jobs, etc. But you see, in Indian society, scheduled caste community, their secular status has improved. Secular status means that their educational attainment has improved, they are now in government jobs, but their ritualistic status has not improved to a very large extent. Ritualistic status means that in the hierarchy, still they are often treated as belonging into the lower part. And this we have seen sometimes in the news, etc. also. So this is something that is there. However, the Supreme Court judgment is appreciable, and the proposal that they have kept forward is really positive and progressive. So that is all guys about this particular video. I hope that you have understood it. Thank you so much.